Welcome back to the Two-Way Report. California, the most Marxist state in the US as of the making of this video, never fails to amuse with their idiotic anti-two-way laws. This time, we'll talk about Senate Bill 452, which proposes a complete ban on new handguns from 2027 onward. This isn't a joke, it's a serious bill introduced by California. As you may already know, getting on the California handgun roster involves meeting certain requirements, including microstamping. For the last 1.5 decades, California has been advocating for microstamping and even passed a law mandating it in 2007. However, the law has been met with controversy ever since. Last year, New York also passed a similar law, thereby setting a precedent. Now that both California and New York have implemented it, the push is to make it a nationwide requirement. Unfortunately, this violates the Second Amendment and infringes on individual privacy, just like many other policies. If you've never heard of it, microstamping is supposedly a process where a laser etching tool creates a microscopic engraving on the firing pin of a gun at the factory where it was made. When the gun is fired, the brass cartridge casing is discharged, and the hammer leaves a microscopic mark on the casing at the point of contact, that is, the primer. This mark can be identified when it is struck, and the bullet is ejected, allowing experts to identify the gun it came from by examining it under a microscope. The whole microstamping bit is questionable, as the ATF and all law enforcement agencies in the US are already capable of using ballistics to identify the source of a bullet. Each gun is tested, but microstamping takes it a step further by allowing experts to locate the gun before they find the brass. Manufacturers like Smith & Wesson refuse to comply with the law and sell microstamped firearms in California. This is precisely what California wanted, for manufacturers to comply with the law or refuse to sell in the state. As a result, California no longer has legal gun sales. For microstamping to work, the state would need to have a record of each gun, similar to how firearms can be registered with manufacturers like Smith & Wesson. When a gun is fired and brass is left behind, authorities can trace it back to the owner and their residence. This is considered an infringement on privacy, which is a significant argument against the law. Additionally, the law doesn't apply to law enforcement, meaning their guns aren't subject to microstamping. This is a significant concern for gun manufacturers who have refused to comply with the law in California. Microstamping is nothing more than a fantasy created by anti-gun politicians who were inspired by some Judge Dredd movie where DNA-stamped shots were shown. In reality, the technology doesn't exist, and the state's tests used to approve the technology involved firing over 20 rounds to piece together one serial number. And if that's not enough, after several hundred rounds, the serial number that was laser etched on the firing pin was damaged irreversibly, rendering it unrecognizable, regardless of how many spent casings were recovered. Firing pins must have a specific hardness to prevent deformation and breakage. They should ideally last between 5,000 to 10,000 rounds, not just a few hundred. However, the firing pins made specifically for the microstamping test were too hard and broke after just a few hundred rounds. Even worse, the delicate microstamp engraving was still deformed. Therefore, the technology remains nothing more than a fantasy. Additionally, the ATF is already utilizing a comparable method, so there isn't a real-world need for microstamping. There's this story about a woman from a YouTube channel called Prepper University that illustrates this point. I will include a link to her video in the description if any of you want to watch it. So, she said in the video she has had practically zero privacy when one of her guns was stolen sometime in 2010 or 2011. The ATF and the police keep a record of it. She told them it was stolen, but they tried to ask her questions to see if she knew whoever stole it. She was never able to recover the stolen gun. It's been 10 or 15 years, and she still gets letters from the ATF every year. She has moved several times since then, and they finally sent her a letter telling her that her gun has not been recovered. The ATF came to her house asking questions about the gun. They even had the serial number. They said they were going to drop by to ask her questions about it, but they never came. Then, one day, her phone rang at 2 o'clock in the morning while she was asleep. She thought to herself it could be her parents. Maybe somebody could have got hurt. One of them was probably calling to tell her one of them was dead or something or in the hospital. She gets up groggy. She picked up, and the guy introduced himself as some detective from some county police department, and really, the goal was to catch her off guard. So, if you can imagine the absurdity of that situation, the ATF can literally kill you by depriving you of sleep, by calling you every day at 2:30 in the morning when they know you're asleep. I'm sure some of you have experienced something similar, so you all know for a fact that the ATF is already capable of tracking the owner of a particular gun if it was registered. If you'd like to share a similar story, please comment down below. What it all comes down to is microstamping requires a registry, which the ATF already has. Microstamping is going to be redundant at best and fantastical at worst. But going back to California's upcoming handgun ban, the state's handgun roster hasn't seen any recent additions, which is why several lawsuits are working to overturn the roster altogether. Currently, the roster with its microstamping requirement serves as a freeze on new models. Anything already on the roster can remain as long as the models stay the same, providing Californians with some options, albeit limited. There are still some options available that don't require microstamping, and the older models are not subject to the new requirement. Being the true Marxist state that it is, California doesn't find the current situation to its liking, so its anti-gun lawmakers are passing a law to expand the requirement for the handguns roster. They want all handguns to have microstamping, which means that starting in 2027, if Senate Bill 452 were to pass, all new guns sold or bought into the state must have microstamping. This effectively eliminates the roster entirely and necessitates microstamping for anything new entering the state, including those already on the roster. According to the amended version of the bill, starting from January 1st, 2027, licensed firearms dealers cannot sell, offer for sale, exchange, give, transfer, or deliver a semi-automatic pistol unless it has been verified as a microstamping-enabled pistol. It will also be illegal for a person to modify a microstamping-enabled pistol or its components to prevent the production of a microstamp, creating new crimes. The bill will also impose a state-mandated local program. Although there's a date discrepancy between January 1st, 2027 and July 1st, 2027, and it's unclear what will happen during this period, the penal code that will be affected is 27533. The requirement for microstamping on all new handguns by 2027 is an unrealistic demand that's comparable to asking for a time travel button. The technology simply doesn't exist yet and won't be available by 2027, making the requirement nothing more than an outright ban on new firearms. Moreover, two separate federal judges have declared microstamping as one of the provisions of the UHA unconstitutional. This ruling presents a significant challenge for supporters of microstamping in California, as the state is attempting to implement a law that potentially disregards the Constitution. The ruling could also lead to further legal challenges and delays, creating a potentially contentious legal battle. Ultimately, the proposed mandate for microstamping may not be a viable or constitutional option for California, leaving many uncertainties for the future of gun legislation in the state. In recent rulings, two separate federal judges have declared microstamping as well as LCI and MDM unconstitutional. This is a significant issue, as California is attempting to implement a law that circumvents constitutional protections. The state's leaders are unhappy with these rulings and seem to be ignoring the judges' decisions in favor of pushing forward with their agenda. This is a concerning pattern in California's politics, as they seem to escalate matters every time they are dissatisfied with a decision, similar to their approach with the carry law. Instead of addressing the issue and respecting constitutional protections, they're attempting to take it to the next level with SB 452. This could lead to further legal challenges and a potentially dragging legal battle. The proposed mandate for microstamping would not stand up in court. It's highly unlikely that the provision would be deemed unconstitutional by a court of law. However, the chances of the bill passing in California are not entirely impossible. The state's leadership holds a dominant majority and can push through legislation as they see fit, even if it ultimately ends up in lengthy legal battles. The idea of microstamping is far-fetched and unconstitutional, so we should stay informed about the proposed legislation and its potential impact on gun owners in California. If you'd like to learn more about Senate Bill 452, I'll make sure a link to legislation will be included below. Feel free to read it for yourself. And regrettably, that's all the time we have for today. If you care about your Second Amendment rights, please smash that like button and share this video with your family and friends who live in California just so they know what's happening. And tap that notification bell too while you're at it. Thanks and have a good one.